Introduction to Insolvency, Understanding the Basics. Welcome to our first episode of IO Insolvency Options with Darren Vardy, the Managing Director of Insolvency Options and a registered liquidator with over 30 years of experience helping businesses and individuals navigate financial challenges. In today's episode, Darren shares his journey into insolvency, explains what insolvency actually means, and reveals the warning signs every business owner needs to recognize. We'll explore when to seek help and the difference between corporate and personal insolvency. You'll understand the fundamentals of insolvency, know when to seek professional advice, and learn why acting early gives you the most options. I'm your co-host Anthony Pearl. Let's dive into unlocking more about insolvency options. Darren, let's focus a little bit on corporate insolvency. I think it's important that we start off with the simple terminology because I think a lot of people hear these words and maybe don't fully understand it. They think they know what it means, but they don't really know what it means. So just unpack the idea of liquidation first. What does that actually mean?
So liquidation is where a company is essentially wound up. A liquidator is appointed either voluntarily by its directors and shareholders or by the court. Now, the purpose of a liquidator is to secure, protect and realise a company's assets, then in accordance with the priorities set out in the Corporations Act, distribute whatever surplus realisations are available back to the company's creditors. So on a liquidation, a business will, if it hasn't already prior to a liquidator's appointment, a business will cease to trade upon the appointment or shortly thereafter the appointment. It is possible for a liquidator to continue to trade the business for a short period of time for the purposes of realising the most out of a company's assets. But generally, that trading on period will generally only go for weeks, not months.
Despite the fact that we seem to see some of these retail outlets that have liquidation sales that seem to last for years, right? That's a little bit of marketing that goes on there, I think.
I think it's fair to say that the liquidation sales that you refer to relate to liquidation of stock, as in sale or realisation of stock sales, as opposed to liquidation of company, correct?
I do recall, and I hope this is a true story because I want it to be, there was someone that tried to register or at least operate under the name Closing Down Sale. And I think that got pulled. I think it was so the story goes that they weren't allowed to continue to do that. But that was the name of the shop and that was where it was going on for a few years until people kind of went, hang on, this is not really right. You're not really closing down, are you?
One would suggest there may have been a little bit of misleading advertising there.
It's just a tad. But I think in all seriousness, I mean, what are the implications of someone going into, or a corporate going into liquidation? Because that's what we're focused on at the moment. Does it mean that for that person that's, whose business it is that's the end of the line for them?
No, it doesn't. It's the end of the line for that entity and it can be the end of the line for that business. But it is possible for the business to be sold by the liquidator to another party. That is one of the outcomes which can achieve a greater return than simply a breakup of the assets and a realisation, say, via an auction basis on the assets. So quite often a sale of business will provide for a better return in a liquidation scenario, whilst it's arguable that goodwill, or there may not be that much goodwill attached to the business, simply having the business in situ and operating can provide a better return than ceasing the trade, sending all the assets out to auction for realisation basis. As for a director can be a director of another entity post-liquidation. The only way a director is prohibited from being a director is if they themselves become personally bankrupt, or if ASIC deem that they are not a fit and proper person to be a director and ban them from being a director of a company.
So how common is it for someone, for a corporate structure, to go into liquidation, then find themselves bought out by the people who were really running it before, just set up under a new entity?
Look, it can be common. Absolutely. The directors of companies where the company has been placed into liquidation, they still have to earn a living. And it might be that the business in which they have operated is an industry which is what they're either licensed to do or they have education in, and that is their vocation. So at the end of the day, those directors still need to work and put food on the table. Is obviously frowned upon if these directors are being seen to be doing this on a regular occurrence. That certainly would be frowned upon, and that would certainly be looked at by the statutory bodies. However, where a business owner has traded a business and for one reason or another has incurred an event which has had a adverse financial impact on the company, it may be that they place the company into liquidation, set up a new company, and then look to buy the business back or buy the assets to enable them to operate a business. And in those circumstances, again, that could provide a greater return into the liquidation from the realisation of the assets than simply breaking the assets up and sending them to auction. Because at the end of the day, it's all about maximising the value of the company's assets to then repay those to creditors.
And I imagine in a lot of cases, there aren't a lot of assets in the business. I mean, if people are renting a space, that's not an asset. If it's largely service driven, or if it's driven by product that is, coming and sitting on a shelf and then going out straight away, there can be a lot of businesses that don't have a lot of assets in them.
Particularly in the service industry, yes. Yes, and particularly with a lot of small businesses, we're finding that even with the change in the manner in which people do business these days, there is less need to warehouse stock with the advent of drop shipping and third-party logistics, where it's more of a just-in-time type of sale than it is, gone are the days where there were warehouses full of stock ready for the sales to come through. Now a lot of people drop ship where the stock is manufactured and held by the manufacturer and then delivered direct to the customer, which makes sense because, again, that's one way of reducing the cost of a business is to reduce the stock holding and reduce the warehousing costs of same. As businesses have grown, they've found more inventive ways of actually doing business to keep those costs down to increase margin, which has been a positive.
And just while we're on the subject of liquidation as well, I mean, I guess the question is do people see liquidation as, particularly in compared to something like, bankruptcy and the like, is liquidation a valid tactic to put a business in a better situation? And it's a reset. I mean, things like, they're in a lease that just isn't right for them. And is it the best way to get out of that, or other arrangements and things that sometimes it's a good business tactic to reconfigure?
Not really, because liquidation is the end. Generally, once a company goes into liquidation, there is actually no coming back out of liquidation. It may be that a cause of liquidation could be a lease contract with which the entity is no longer able to afford. Therefore, its only alternative is that. The use of voluntary administration and deed of company arrangement and the use of a small business restructure could, in fact, be a strategy to attempt to deal with some of those onerous contracts, such as a lease. And those particular avenues or alternatives to liquidation are probably best suited in dealing with things such as that.
Yeah, there's certainly stuff that you hear all the time, and there's a number, particularly in the retail sector, I'd imagine, where people are, they're on a high, there's an opportunity to get into a shopping centre, and they think by being in the shopping centre is going to increase traffic, increase sales, etc. And then they're whatever period of time down the track when they might realise that has not achieved the same levels that have hoped, and they're starting to go backwards.
And one of the major issues with those types of leases is the personal guarantee component that goes with them. The majority of those, for want of a better term, shopping centre leases, unless negotiated out, will have a standard personal guarantee clause. So what you quite often find is that whilst the business was unable to be profitable and ends up getting wound up with a significant debt owing to in respect to its suppliers and creditors and maybe some tax, quite often we find that the landlord is generally paid up to date because the business owners want to ensure that they can open the doors on a daily, weekly, monthly basis.
Uh-huh.
But when the company is placed in a liquidation mid-lease, it doesn't end there because the leasing owner is able to make a claim for the balance, generally for the balance of the lease, for which not only the company is personally liable for the balance, despite being up to date with its rent and not in arrears,
Uh,
a claim is often made against the company and then also made against the directors personally, pursuant to the personal guarantees. And quite often we've found in those types of scenarios that the company will go into liquidation and then, depending on the financial circumstance of the business owner personally, the business owner may then have to look at a personal insolvency alternative, if not bankruptcy, as a result of that ancillary debt owing pursuant to the lease.
and I imagine that's not an easy thing to negotiate out of a lease for people listening in and contemplating signing a lease at the moment. Those kinds of personal guarantees might be the difference between someone agreeing to lease a space to you and not.
Correct. Now, there is an obligation on the landlords and the like to mitigate any loss. But if after a company is wound up and the space is vacated, if the landlord is unable to relet the space for whatever reason for a significant period of time to the end of the lease, well, then that liability still stays with the business owner personally.
Lot for people to consider in this kind of situation. And I think it's important that we go back to also talking about the different types of liquidation, because we've got, as you mentioned earlier on, there's a situation where you've got the court winding it up versus creditors and the voluntary style. So obviously I imagined that you don't want to end up in a situation where you've got the court winding you up. Is it better to jump before you're pushed?
It depends on the circumstances, absolutely. But what we often find is that if it gets to a court winding up, really the business owners had exhausted all avenues and they're really left with nothing in the business to enable them to deal with the issue at hand. And that issue is being a creditor who is pursuing for a debt owing and rightfully petitioning the court to have a liquidator appointed.
And whose decision is it about which liquidator to use?
The petitioning creditor is the person who obtains a consent from a liquidator to be appointed. So the decision as to the liquidator who will be used is that of the creditor pursuing the debt owing.
And I guess that in itself is a difficult thing to see. How do you find that people make that decision? Is it based on just someone they know? What is the criteria for people choosing someone to fall into that space?
Sure. Well, for someone to be a liquidator, they need to be a registered liquidator with ASIC. And what you often find is that the winding up process is a legal process, and the firm of lawyers that is attending to the winding up process on behalf of the creditor generally has relationships with one or a number of insolvency professionals who they will refer the matter to and obtain a consent from.
There's a lot for people to unpack and work that out. I think, it seems simple, but it's not a straightforward decision to make, because I imagine different people in that space have different approaches as well. And a lot, I imagine, as well, has to do with the people arrangements and how you get on with people, because it is such an emotional environment.
Yes, it is. As with everything, irrespective of the type of appointment, being a voluntary appointment or a court appointment, as insolvency practitioners, we need to approach these matters with a certain amount of empathy. But at the same time, we're also there to do a job. We're there to investigate the company's affairs, determine why it has failed, make sure that there's been nothing untoward that has occurred, and report back to creditors. So irrespective of whether the appointment is via the court or done voluntary, really as a liquidator, we act for the creditors and we're there to provide them with a report as to why they're not getting paid.
Well, that's it for this episode of the IO Insolvency Options podcast. I hope you've got plenty of valuable knowledge and practical steps for whatever your situation is from Darren today. And if you need guidance on insolvency matters, contact Darren Vardy directly at insolvencyoptions.com.au or call 1800 463 328. Or of course, you can connect with Darren on LinkedIn. Details in the show notes below. With over 30 years of experience, Darren and his team provide personalized solutions for both personal and corporate insolvency challenges. This episode was produced by my team at podcastdoneforyou.com.au, helping professionals share their expertise through powerful podcast content. If you found value in today's episode, please like, comment, and subscribe to the IO Insolvency Options podcast wherever you are listening to this. Your engagement helps us reach more business owners who need these crucial insights. Until next time, remember, there's always a way forward when you know your options.